So I know you probably saw that that motion was denied by the defense attorneys in the Karen Reed case. First and foremost, were you surprised or shocked that it was denied?
I was, in light of the number of people, jurors, that contacted both the prosecution and the defendant. I'm surprised that she simply denied the motion. Clearly, there's some confusion here at the very least, and it's incumbent upon any judge to determine what that confusion is. She's received affidavits indicating that people found an acquittal on murder. If that wasn't the case, it doesn't take too much to make that determination. Really, what should happen is in chambers on the record, the foreman should come in and tell the court what happened. The judge didn't want to hear that for whatever reason. And in light of the fact that this woman is on trial for murder, I think she should have at least inquired a little bit further as to what the confusion is about.
Could you see the defense possibly making an appeal?
Absolutely. I mean, this is an unusual circumstance, but for the court to not act at all, in light of the fact that 4 separate jurors at 4 separate times came out and said that they had a unanimous verdict of not guilty on the murder, to do nothing and just deny a motion when a person's life is at risk like this, I have no question that there will be a strong issue on appeal.
Knowing that the jurors were just deadlocked on just one count of the 3, why couldn't they just make a split decision or just say, we find her not guilty on the murder, we find her not guilty on leaving the scene, but we're just unsure of this last one? Could they have done that? Or
they could have done that. So clearly where the confusion came in is that they must have found her not guilty on the murder, but were deadlocked on what we call the lesser included offense of manslaughter. They could have come back with that. If they found her not guilty on the murder, then jeopardy does attach and she cannot be retried for it, even if they are not hung on the lesser included offenses. So they could have done that. I think because of the way it came out, they were so confused on the jury form that they didn't know they could do that. I think they all agreed to not guilty on the murder, but because they were hung on the manslaughter, they came back with a note saying that they were hung. They didn't go into details, and that's where the confusion lies. If the court asks a juror to come in and explain why they felt that this was a unanimous verdict after the fact, she should do that, but she hasn't.
And now that these jurors have come forward, even though the motion has been denied, doesn't this kind of put a little bit of a damper on the prosecution's case? Or could it possibly offer some sort of deal, knowing that the jurors have once already kind of said, we didn't see her guilty of murder, we didn't see her guilty of leaving the scene, but the lesser of the counts were like, so could they kind of come together and say, should we maybe offer her a deal? Could that be a possibility?
It's a very strong possibility. Having been a prosecutor, if I had this case and I knew that there was some evidence out there that these jurors were going to come back not guilty on murder, I would definitely make an offer. The question is whether or not the defense would take it. You run a risk by not taking an offer of manslaughter, but I think it would be wise for the prosecution to do that. I think the evidence that came out during the course of this trial really had an issue with some type of problem relative to the police and whether she actually did this. This is putting aside what the jurors did in this case. Just the facts themselves created a real issue of doubt as far as I saw.
And also, this case is extremely high profile, local, nation networks, everyone's kind of watching it. Could this change venues? Can they find a jury that has no opinion, no bias? Could that be a possibility?
Probably not. Because they didn't get a change of venue in the first case, they probably won't get one in the second case come January. And I think even though it's high profile, the problem is it's high profile nationally. So there's nowhere that they can go where no one has heard about this case. And so as a result, I think it'll be tried in the same courthouse where it's being tried now.
And now that this trial is set for January, do you see any other changes happening that could maybe pause the trial or push it back? Or
this most recent motion, denial of this motion, might create an emergency appeal. The reason for that is because if this jury, it's determined somehow, and the case is remanded back to the court to make a determination as to whether there was a unanimous verdict on not guilty, that will come before the next trial. So the appellate court may very well take this and say, look, let's at least find out what's going on here. And if it's determined at that point that, yes, they found her not guilty of murder, then of course the trial wouldn't go forward. If they found that that was not the case, then jeopardy would not have attached and they could go forward. But that's something that should be determined before January.
And then now, since before January also, how should prosecution move forward?
Well, I think they're going to have to move forward with the same way they moved forward before. With a mistrial, they do have the opportunity to clean up some of their witnesses. Some were very, very bad. Maybe they won't call them at all. So they'll have the opportunity to have this case tried again, maybe a little cleaner than the first time. But they still really have an uphill battle, in my opinion.
Anything else that you think the judge should, I know you were talking earlier, maybe inquire more about? What should she do on her front as well?
As it relates to this motion, what she should have done, as soon as she heard that there were issues of a unanimous not guilty verdict, she should have brought the foreman in under oath in chambers, so the foreman is noted as to who he is or who she is, and ask what took place. If she is satisfied that there was confusion and that there was not guilty on the murder charge and leaving the scene, death resulting, then jeopardy attaches and those counts needed to be dismissed. The fact that she didn't do that is astounding, quite frankly, because at the end of the day, at the very least, all this is confusion. Something happened in that jury room that caused a lot of confusion, and she can clear that up, but she's choosing not to.
Do you think the next jury, if we do get to that trial, could they also kind of come to the same conclusion, maybe be deadlocked on that manslaughter charge, or maybe it could go either way?
I would suggest to you that the next jury form will say, if you find this defendant not guilty on counts 1 and 2, that being the major charges of murder and leaving the scene of the accident, death resulting, you may still find her guilty of the lesser included. That should be in the form. And if it is, then there won't be any confusion. Then we'll see how the form is written out, and that will be clear. And that probably will happen in the second case.